Good morning, good afternoon, and good evening. On behalf of Dean Gary Jenkins and the University of Minnesota Law School and its advancement staff, we welcome you to this special international CLE offering from the University of Minnesota Law School addressing global perspectives of IP law. We are thrilled to have a worldwide panel and audience representative of our very global law school population of students and alumni. Professor Tom Cotter and panelist Yen Florzak are in the Twin Cities, and our other panelists are zooming in from New York City, Seoul, Taipei, and Paris. And to add a little flavor, I'm in Toronto this morning. So today's webinar is being recorded, and the link to the recording will be shared via email following the event. We have live audio captioning enabled. Please click on the live transcript feature at the bottom of your Zoom screen to view or hide these captions throughout the discussion. We will do our best to reserve time at the end to pose questions submitted by the Q&A feature found at the bottom of your Zoom screen. I'd like to introduce our moderator, Professor Tom Cotter. He is the Taft, Stettinius, and Hollister Professor of Law and Associate Dean for Research and Planning at the Law School. He joined the law school staff in 2006. His teaching and scholarship focuses on intellectual property law, antitrust, and law and economics. He is a prolific scholar with many books and articles, including those published in the California Law Review, the Georgetown Law Journal, the Iowa Law Review, the Minnesota Law Review, among others. He was elected to membership in the ALI in 2019. Professor Cotter, take it away.
Thank you very much, Tim. And I would like to begin by introducing our panelists. I will start with Yen Florzak. Yen is the Chief Intellectual Property Counsel for 3M Company. From 2016 to 2019, she led 3M's Asia Pacific intellectual property function headquartered in Shanghai. Ms. Florzak has held various positions of increasing responsibilities in her more than 20 years of experience with 3M. Before entering the legal profession, she gained experience as an engineer at 3M and at Abbott Laboratories. She received her law degree from the University of Minnesota Law School. And before that, she received her Bachelor of Science degrees from the University of Minnesota in chemical engineering and in material sciences and engineering. Secondly, Grace Anhee Lee is a partner at H&P International Patent and Law Office in Seoul, South Korea. And prior to that, Grace worked as an in-house counsel in the intellectual property rights field at LG CNS Company Limited, focusing on information technology and renewable energy, and was an associate at Hamre, Schuman, Mueller & Larson, PC. She is a 2015 graduate of the University of Minnesota Law School, and I'm happy to say one of my former students. Grace had also worked as a Korean patent attorney for about 10 years before attending the University of Minnesota Law School. Xinghao Wang is Director of Global IP Enforcement at Alibaba Group. He joined Alibaba Group in 2015. He works with international brands and retail partners, industry associations, government regulators, law enforcement, and other organizations to advance Alibaba Group's IP protection efforts. Before joining Alibaba, Dr. Wang was an IP attorney at Hamre, Schuman, Mueller & Larson in Minneapolis, focusing on helping US companies protect their IP rights worldwide, including in China. Dr. Wang is a 2011 graduate of Minnesota Law and also one of my former students. Peiwan Cao is General Counsel, Chief Legal Officer at Giant Bicycles Group's Global Legal Center in Taiwan. Prior to joining Giant Bicycles, Peiwan served as head of legal for Delta Electronic Groups in Europe, the Middle East, and Africa. Peiwan is a 2007 graduate of the University of Minnesota Law School. And then our fifth panelist, Coralie Pritchard, is an associate with Astera in Paris, France, focusing on intellectual property, information technology, and data privacy. Prior to joining Astera, Coralie has worked at Gowling WLG, Astin, and Armango Gerlin. Coralie is a 2018 LLM graduate of the University of Minnesota Law School, and again, one of my former students, and she is also licensed to practice law in the state of New York. So welcome, panelists, and I'd like to begin by throwing out a question for all of you. How have you seen patent law or other areas of intellectual property law change, if at all, over the past few years? in your country and your practice situation? What has been most notable in your own experience?
Maybe I can jump in. From my point of view, there have been like two general tendencies in the patent law changes. So the first one is the willingness to give more strength to the patent registration in general. For example, in France, we had reforms where we gave more power to the French Patent Office in order to assess whether a patent should be registered or not. We also created an opposition procedure for third parties to be able to challenge the patent registration in front of a court. The second tendency in general is the willingness to add more flexibility to the patent registration. I guess some of you have heard about that, but in Europe, we've been working for quite a long time on the European unitary patents. And so it's going to give the companies the opportunity to register their patent in up to the 25 states of the European Union members by going through only one registration process. So it's going to save so much time and so much money for everyone. It's going to be great. And it's supposed to enter into force next year, in next April. So we are very excited about that, and we will see how things are going through.
Xinghao?
So I'm actually just going to speak from e-commerce platform perspective, right? As at least most of you probably know, Alibaba Group operates a few different platforms that serve the consumers in China, as well as help sellers mainly in China to sell internationally. And the one question we always face with respect to patent is whether we should help rights holder to enforce their patent rights on platforms without a judicial decision, right? Because this is it's a very difficult question. Patents can be challenged in multiple ways, and generally speaking, platform does not have the capacity to decide whether there's any prior arts or whether the scope, whether the product fall into the scope of protection. However, the one recent change, especially from China, is that China have an e-commerce law. I think it's enacted in 2019. That in the e-commerce law, it's actually specifically said patent rights, patent right holders can submit a takedown request based on valid patent, and the patent has to take the necessary steps to stop the infringement. However, the interpretation is still difficult because courts still have their role in deciding whether there's whether the patent is invalid or whether the patent is infringed. So, from our point of view, what we do is that we enact a procedure where the patent rights holder can submit a takedown request based on their own analysis of a patent infringement, pretty much like submit a claim chart. And then we also request the opposing party to submit their reasoning for not infringing, and then we sort of compare and decide whether in this case we already have enough evidence, assuming the patent is valid, there is a likelihood of infringement. But from legal perspective, I think the e-commerce law in China at least makes clear that the patent owners can enforce their IP rights without a judicial decision.
That's very interesting. It sounds like
yeah.
the notice and takedown that we have in the US for copyright.
Yes, the procedure is pretty much the same, except that we are not taking actions with respect to listing until both parties submit their documents, and we have a chance to review to see whether there's a likelihood of infringement. Even the opposing party don't submit anything, then we still want to see at least there is a likelihood of infringement based on the analysis submitted by the patent holders.
Yes.
So Professor Carr, if I may, Xinghao, how does that system? I mean, first of all, let me say I applaud Alibaba for taking this step and using the e-commerce law in China. And second, have you had any history thus far, and how successful? How many parties have taken advantage of this this tool that Alibaba has to offer?
So respect to patent, we actually have this procedure similar to what we have now, even before the e-commerce law. We actually have this procedure for a long time. Now, it's actually a great question, right? With respect to what kind of patent would be most effective to enforce, I can tell you the design patent is actually the easiest to enforce because design patent can just compare, it's the same, the end of the case. So we, unless the other party provide any documents saying, okay, I have a prior sale, then a patent priority date, or the patent already, I mean, the product is being released before the patent being granted. But without that, then design patent is actually the easiest, right? And the utility or invention patents is a little bit difficult to enforce. Now, from our point of view, is that if we can see every features from the information we already have on our platform, that if all those reasonably fall into the interpretation of the patent claims, then we at least allow this request to go through, then the other party can oppose. But from the rights holder point of view, to be honest, I think the patent and even copyrights are being used more and more. The reason is that through the years of enforcement, trademark enforcement actually is going to downhill, because trademark enforcement is easy. You use my trademark, it's easy. So people tend to not use your trademark. They may feel, okay, I sell a product that may look similar to yours, may function similarly, and they probably don't even know there's a patent infringement just because there's so many patents out there. So there's many reasons that the patents actually becomes more and more prominent in the efforts of gain market advantage on e-commerce platforms.
Well, thank you, Professor Cotter. I'm sorry, I just had to interject in that question. I'm sorry to derail your discussion.
No, that was an excellent question. Thank you for doing that.
So let me share my thoughts about U.S. patent law. So, just to start out with, I, along with my company 3M, really believe that the availability of high quality, reliable U.S. patent protection is just a necessary part of our innovation ecosystem. It's the key to the future of the prosperity of the participants who use the system in the U.S. But as many of you may know, there has been quite a few changes in the U.S. patent law, and it's been a decade in the making. And so I would say today that the U.S. patent system, from my perspective, someone who's a right holder and representing a company that's patent right holders, the system is less reliable. It's fair to say it's less reliable today because of several factors. One is the case law from the U.S. Supreme Court. There's a quartet of cases from the U.S. Supreme Court that really has modified or judicially changed what constitutes patentable subject matter. So that's one. And I can discuss that as we move on. So I don't want to take up all the time to go through that. It's quite complex. And the other one is, as many of the participants may know, in 2012, the United States Congress enacted the America Invents Act, and which formed this patent trial and appeal board within the United States Patent and Trademark Office to allow for post-grant review and inter parties review of issued U.S. patents. And I think that too, while there was, the idea was right for efficiency and cost, I think we've seen some unintended consequences that has put our U.S. patent system in somewhat of a less reliable today than before. So I'll stop there and let the other panelists speak.
Grace, Pei-Wan.
Okay, so in Korea, the biggest trend of, can I talk? Okay,
sorry,
so
should I jump in or?
Oh, okay.
Oh, either of you. Grace, why don't you go first, and then Pei-Wan.
Okay, no problem.
Okay, so the biggest trend of changes in patent law in Korea over the past few years has been the strengthening of the protection of patent holders. It may sound too obvious, but in fact, in Korea, until a a few years ago, what I felt was important in the field of intellectual property rights was the strengthening of national industrial development through the balance between the public interest and protection of patent holders. But as of July 9, 2019, a punitive damage compensation system was legally introduced in Korean Patent Act. And also there is an active movement to introduce a Korean-style discovery system similar to American one. So it is expected to be formally introduced into Korean Patent Act in near future. So our system is going to protect the patent holders more and more. And then also in addition, in the revised Patent Act in 2022, the period to apply for divisional application was extended up to even after the appeal trial against the final rejection is over. And the condition for restoring a patent right was remarkably relaxed. And further, applicants can make a request for re-examination even after an allowance is issued for the application. Such changes will actually extend an opportunity for the applicants to make correction on their applicants to make stronger patents for their market. Actually, these all kinds of changes are really remarkable in Korea, because previously the government really tried to protect the industry. Then industry development actually they had to use the technology, so they wanted to protect more the industry. But now they are going they tend to protect the patent holders more and more, and then they want the patent holders to expand their rights. So those kind of things are in Korea are actually people should pay attention to in Korean Patent Act.
And Peiwan?
Okay, thank you, Professor Cotter. And first of all, I would like to thank this opportunity, for this kind invitation for me to return to Minnesota, even though online after 15 years after my graduation. And, talking about the changes in patent law, I could offer my view briefly on patent law in Taiwan. Actually, Taiwan has actually amended the Patent Act several times in the past 3 years. Okay, first in 2019, 2020, 2021, and again this year we are actually foreseeing another amendment coming soon. And you will be surprised to find out that when Xinhao was talking about how easy it will be to enforce a design patent, and back in 3 years ago here in Taiwan, the design patent law was not, I would say, as well drafted as maybe the other major countries like the US or in Europe or Japan or South Korea. And so in the past 3 years, we could see that Patent Act actually changed a lot in Taiwan. For example, the statutory grace period was extended from 6 months to 12 months, which is actually normal, right, in a lot of countries. But imagine that in the past, you could only, once you have disclosed the design, if you actually waited until 7 months or 8 months, then sorry, you're out of the game. You cannot apply for a design patent because you forgot to submit it before that. And actually, 3 years ago, the Patent Act also extended the exclusive rights for the design patent from 12 years to 15 years. And you would say, wow, 12 years is really short. But 15 years now is actually better, and protecting the design patent rights actually far better than previously. And of course, also on certain examination guidelines, those were also amended. So actually granted a lot of, let's say, more latitude on the applicants of design patents on certain image designs, which no longer needs to be applied to physical objects. And so if you use that on computer software products, those actually are very good news to a lot of applicants. So that's, I would say, maybe the most biggest changes in the past 3 years in Taiwan regarding patent law. That's my, I would say, a quick response. All right, thank you.
All right, thank you. I'd like to move on and ask our panelists, what are some of the most common, or alternatively, what are the unique challenges that innovators, entrepreneurs, and companies face today? And maybe, Yen, I'll start with you because I think you alluded to some of this in your opening comments. Oh, and you need to unmute yourself.
So, yes, thank you. Thank you, Professor Cotter. So I would say top of mind and of immense concern is the Supreme Court's decisions on what constitutes eligible subject matter for patenting under Section 101 of the U.S. patent law. So, as you know, the Supreme Court has rendered opinions in 4 cases: the Mayo case, the Myriad case, the Bilski case, and the Alice case, and those cases have substantially restricted the scope of patent eligible subject matter to fields such as artificial intelligence, personalized medicines, therapeutics, biologics. And for a company like 3M, who we are going more and more into the software space, which is one of the fields that is really under question, it causes a fair amount of uncertainty in our practice, and for our practitioners, and by the way, for the USPTO examiners. So I think that is one that those who are looking to participate in that field do face a fair amount of uncertainty. There is a movement abound by many interested stakeholders to try and amend that, to get clarity on what Section 101 really means. There is, of course, a pro-reform camp who really wants to look at bringing the statute back to its original intent and clarifying the language. And then, of course, there's the other side of the camp as well. So I would say for those who are seeking to get patent rights in the U.S., the area of subject matter eligibility is of concern at this point in time.
What do some of our other panelists think are some of the common or unique challenges facing innovators? Xinghao?
So again, I'm talking about from e-commerce platform perspective, right? Because of course the e-commerce becomes more and more important for business, especially for SMEs, to be honest, because it's easier for them to launch their products. But if you're looking at the patent infringement analysis, right? I mean, if you go to the court, it costs millions, tens of millions of dollars just to figure out whether the patent is valid or this product has infringed that patents. But on an e-commerce platform, you're just talking about the removal listing, right? So there's a huge disparity between what you actually the current procedure is in a judicial system, and also the task of removing a listing, right? So you don't want to spend tens of millions of dollars just to remove a listing. Even though we have a system in place where we allow you to submit a takedown request based on your own analysis and based on other materials submitted by opposing party, but from platform perspective, we also don't want to play the role of a court, right? So from, at least from my personal point of view, I wish there is a middle ground where there's some kind of judicial venue where expert can just look at the materials and give an opinion, not a law firm where people pay them to do an opinion, but either is a mutual party that has no interest in either one, give an expert opinion, so both parties can work on that. And I wish that system exists to remove some of the obstacles, just to remove a listing,
Yeah, I think that's if I can just comment, this is so interesting. So as someone who's lived in Shanghai and practiced in China for 3 years, I will say first and foremost, the China patent enforcement system is great. It's really very fast, it's efficient. It takes, depending on who the parties are, it could take one party, under Chinese law, a little bit longer to get through the system. But on the other hand, if we're just looking at for e-commerce, I mean, my experience has been that you take it down in Alibaba, then it'll pop up in what is it, WeChat or Dingguoguo. So I think I applaud your initiative to find a middle ground between the two. But for practitioners who or for companies who do business in China, I think using the Chinese patent system isn't a bad way to go, actually.
Taiwan?
Well, thank you. Actually, I want to echo what Xinhao and Yan said. For me, that's actually a brand protection issue, because when we talk about, we are talking about patent law, but actually for IP, as a general counsel of a multinational, branding company such as Giant, we sell bicycles all over the world, millions of bikes and e-bikes. And what matters is actually our brand. And we cannot just protect the brand merely by using trademark protection, trademark registration. Of course, those can be easily enforced. But a lot of times nowadays, the infringement actually happen on websites, e-commerce, like on Alibaba platforms. I must say, Xinhao, you probably need to deal with a lot like that. And even the websites and also e-commerce channels, we take down one, then the other pop up, in a few hours. And then there are social media where the Facebook pages and also apps, and there are cyber squatting, like domain name registration by someone else in different countries. And then you just have everything coming up almost on every, let's say, front. And that's actually one of the biggest challenges I see, that for especially branding companies, multinational presence, that's something we need to deal with. And traditional trademark protection is definitely not enough. That's my 2 cents.
You make a good point. Thanks, Penhua.
Yeah, and I can add a little bit more flavor from point of view of platform, right? If there is no any kind of a judicial decision, then it's very hard to block the product on the platform. We have to do this case by case, right? Because it's between the two parties. But if there is sort of at least some authority there saying, hey, I think there is likelihood of infringement and think the patent is valid, then you can do maybe at least on our own platforms, we can have a prohibition for that item that becomes a market exclusion. Without that, then you are still talking about single cases by case. So it's between you and the seller. So that's.
I guess we should call Xinhao after this session.
but from a philosophical point of view, that is a kind of issue for us, is that I cannot base on one party, one seller, a case between you and one seller, and block everything from other people. So that's
we need a systemic, solution to that issue. And like I said, just case by case handling is definitely a headache. And for us, we have hundreds of websites to follow and to take down. And I don't know how to deal with that. Maybe Alibaba
I can agree with you. I can
innovative way.
Coralie or Grace, do you have anything you'd like to add to this particular part of the discussion?
In Korea, actually, these days, there are many new era technologies, such as NFT or AI-related technologies. So actually, those kind of concepts are really hard to define with a traditional patent concept or traditional intellectual property. So these days, we have a little headache to give advice to our client, because clients want us to guarantee that their patent application will be allowed, or their patent, their invention can be protected well. But sometimes NFT related technology or AI related technology, sometimes it's a little hard to guarantee for us to then, especially when I apply for the European application about the AI related technology, that actually I got an allowance from other countries, but we had to abandon the patent application in European countries, because European standard was really hard, stricter than others. So this kind of new era technology, it was a kind of headache for us to give legal advice to them, and then also maybe we need to discuss more about those kind of new concept of the intellectual property. So those kind of things are really hot in Korea these days.
Yeah, I think I mean I completely agree with you. I really have the feeling in general that technology is so much ahead of law, and we are just running behind. It makes things very complicated because I mean everything is unpredictable for innovators and entrepreneurs. So I think we need to work on that. And I mean that's my general feeling. Harmonization of the law is a very good tool for everyone to work together. I mean, unpredictability is something larger than that. We are living in very complicated times because of the COVID, because of the war in Ukraine as well. So I think it's a very, very great challenge for entrepreneurs today. Something that is a bit specific to France as well. So my practice focus more on patent transaction, not that much on patent litigation. So that's why maybe my point of view is a bit different from my co-panelists. We are witnessing in France a lot of partnerships between public entities and private companies as well to develop patents. And most of the time, they're, of course, entering into partnership agreements in order to organize the exploitation of the patents. But of course, you know, those agreements are sometimes very narrow, and it's complicated for entrepreneurs to, for example, in the context of an acquisition, to try to go over this partnership agreement, try to find a way to use the patent in other domains as well, because the public entities have a very narrow point of view on how you should use patents. So that's one of the issue we've got in France, for example.
So many of you, your comments, I think, kind of naturally lead to what was going to be my next question anyway, and that is, well, given that commerce is global, but intellectual property rights traditionally are territorial, how do we create this global network of collaboration? If there are different laws, if there are conflicting laws, there is a degree of harmonization, but still lots of differences among the nations of the world. And how do you navigate this, and what can we do to improve it? So who would like to address that one?
So I'll take a stab at it, Professor Cotter. I think you're right in that there is some harmonization in terms of the upfront, the front end, of, you know, obtaining the patent, what's novel, what's, you know, what has inventive step, or what's unobvious, what has utility. I think that is more standardized. And as I compare and look at other areas of law, I think the patent law world really benefits from that. I think on the back end side, you're absolutely right. There's a lot of differences on the enforcement side. And my experience in enforcing in Germany, in Italy, in Korea, in Japan shows me that there is, I don't know how we really get over that, because like you say, jurisdictions, you know, it's hard to get a Japanese court to agree or listen to or take a nod from, let's say, a German court, for example. And I get that. That makes a lot of sense. They have their sovereignty to think about it. In terms of how we can go collaborate, I mean, the one way that we do it is we actually join organizations that can collectively speak louder than one company like 3M. So we are part of an industry organization to really help move some of these big rocks forward, to take the big rocks and make them smaller rocks, so to speak. And I think that's one way that 3M has navigated in this tumultuous, uncertain, and on the enforcement side, is by joining such organizations. And then the other thing we do is, I would say we also use our government affairs people, because, you know, as one voice, we can speak louder as a 3M company, and our government affairs can get an audience with certain stakeholders who are in a position to change the law, or to at least listen to interested stakeholders who really have a concern and sometimes solutions to bring forth to amend the laws. So I'll stop there. Thank you for asking the question.
Peiwan, I think you had a hand up.
Yes. Well, thank you, Professor Cotter. Actually, I want to echo Yan just said. Government affairs is definitely one channel to go through. We actually also try maybe going through some diplomatic channels. Some of them actually under maybe FTA regime, or some of them actually under the WTO regime, the TRIPS agreement. But those actually doesn't work too easily. And of course, the WIPO is another channel, but again, there are limitations there. So joining international organizations like INTA, on the trademarks, or the IPLA, okay, the AIPLA or AIPPI, those kind of international organizations actually you can unite with a lot of different multinational companies and to voice out your concerns, and that actually sometimes can work. Because as one company and in one particular industry like us, we are in the sporting goods industry, or these may not be influencing enough. But if you are not influential, but you can leverage maybe working with like 3M or Alibaba or other major brand names, they can actually unify and forge a bigger force, and that sometimes can actually change a little bit. I remember one of the cases; those actually has some influence in China, or some of them actually in the U.S. So I think those are one of the other channel that can actually help. And the other way, maybe the third way, I would say is that a lot of companies actually doesn't want to invest in government affairs because they thought that's not traditionally in the legal arena. But I found out that a lot of companies actually starting to think that you can actually play a little bit, not just the law in the traditional sense. I mean, in the courtroom, in the litigation, and actually lobbying can actually work. And that we saw that actually happen in Taiwan recently, because, for example, in one case, design patent litigation, Mercedes, from the German, one of the conglomerates, they litigated in Taiwanese court, in the IP court, and actually they also lobbied at the legislative department. And all these branches actually they work together. I think they have some influence there. But anyway, I just want to offer my few observations. Thank you.
Do any of our other panelists have anything you'd like to add about this discussion, Grace?
For me, actually, I'm pursuing smaller opportunity to create the global network of collaboration. For me, it's really hard to go around. These days, it's COVID area. So I'm pursuing to meet people through Facebook and LinkedIn. And also there is a chat application such as Clubhouse. In Clubhouse, there are many IP communities inside. So I have a lot of opportunity to chat with other IP professionals about those kind of issues. So maybe you can use those kind of opportunity to meet others and exchange those kind of opinions, and then make bigger opinions. Because after those kind of discussion, we can make an agreement about the bigger movement. So I think I recommend those kind of things in my experience.
And
If I can
Coralie.
jump in, yes. I completely agree with you again, Grace. I mean, this is very important to have a very strong network, and I think the UMN is helping a lot. I mean, we've all been there, and we've all met people coming from, I don't know, maybe around 20 different countries, and we all know how technical patent law can be. So it's very essential to have, a deeper understanding of the law, and to work with professionals who can help you to navigate through those procedures and everything. So that's why I think it's very important to use this network, to join international association, as you said, Taiwan. meet people and participate in those kind of events as well. I mean, it's very, very interesting to have, these general understandings of how things work in different countries and how we can, try to find link and build bridges basically between our countries. So yeah, that was my point of view.
And Xinghao, would you like to add anything, or I can move on to some other questions otherwise?
Well, the only thing I can add is that, from our own operation point of view, that our international platform, since it's mainly from China to sell to the world, actually only need a patent in one jurisdiction, and then you can remove this listing from this international platform. That basically prohibit the listing showing up in different countries to begin with. But this is a very practical point of view. I think like different platforms do different things. Like Amazon probably have country sites, and then for the country sites, you probably need patents in those corresponding jurisdictions to enforce on their country sites. But for us, at least currently, we have global sites, so you only need a patent in one major jurisdiction.
All right. Well, at this point, I can keep asking questions, but I'd also be happy to take questions from the audience. We have one question from the audience already, asking about newly emerging technologies such as artificial intelligence. So how does the law keep up with these newly emerging technologies, which may involve questions about who the owner is, other questions relating to AI? Does it render some of the unpredictable arts more predictable and have an effect on patent disclosure doctrine? So do any of you have any thoughts about AI or other pioneering technologies and how they are going to be changing things?
Well,
So I
maybe
think-
if
Go
no
ahead,
one's
Ben.
jumping in, I could
Go ahead, Taiwan.
throw a little bit. Actually, I was going to say that actually metaverse or NFT has been pretty hot in Taiwan too, in the legal, not just in the scholars ring, but also in the practitioners ring. And we have been, holding a lot of conferences talking about that, and also, of course, including artificial intelligence. And on artificial intelligence, of course, it also has a lot to do with, let's say, artificial learning and machine learning, and those kind of things. Whether they are patentable, we have received some, guidance from the PTO here in Taiwan, but again, those are not really clear enough. And so I recall in the beginning of this session, Ian was talking about the uncertainty, based on the recent technology developments. Actually, a lot of uncertainty actually surfaced, and we have more and more in that. And metaverse, actually, there's no really very concrete or clear guidance here in Taiwan. And I guess we will need to continue to watch and observe how things will evolve. And that's why, as a branding company, even though I've been preparing to file, for example, trademark registrations, or even thinking about whether there's anything I can protect about the branding images or trademarks, I'm not sure what's the better strategy. And maybe that's something maybe I would like to listen from maybe Professor Cotter or any other panelist. Thank you.
What do some of the other panelists have to think about this?
So I would offer the following. First, it's a very uncertain area of law in the U.S., as my opening comments have stated. I would say if you really want to get into the game, you have to really follow this and jump into the game. That is, get educated and talk to your legislatures, because this really does require a change in the law. And your voice, if you represent inventors, which we all do, and I'm thinking that many of the listeners do too, getting your legislatures to understand the complexity and understand the importance of having patent rights in this emerging technology area, whether it's quantum computing or AI or the metaverse, as Pei Huang has talked about. Your voice is very powerful, or can be powerful, because your legislatures will listen to you. So that's one thing I would offer as something to, if you're really passionate about it and want to make an impact, get into the game is what I would say.
Go ahead.
Well, thank you, yeah.
Xinghao.
So another perspective that at least a small and medium entity can think about is the usability of a patent in this area, even you get one, right? And I can tell you from e-commerce platform point of view, if it's one of your main business channel, they enforce the AI patents extremely difficult without a judicial decision. So when you proceed with applying for patent, of course you want to protect your key technologies, but at the same time you also probably need to consider the business cost and the cost of enforcement and balance that with the patent or the key patents you want to pursue.
And if there are any other comments on this, I'm happy to take them. Otherwise, I can move on to another question from the audience. And this other question relates to the following. So it says, the discussion today has mentioned convenient options for patent enforcement and expanding AI-related software patents. The questioner asks, what balance is required to avoid misuse by non-practicing entities, particularly those of increasing sophistication? So I'd be interested in hearing the panelists' views on those topics. Traditionally, it seems that patent assertion entities have been more of an issue in the United States than in other countries for a variety of reasons, but I know that we are seeing increased participation by non-practicing entities and patent assertion entities elsewhere. So do any of you have any thoughts on that?
Yeah, so as someone who's been representing a company who has seen some of these patent assertion entities, they are difficult. They do raise an emotional factor that we all have to keep at bay. I would say that that is an issue that is being looked at. I think one of the other areas I talked about earlier is the use of our patent trial and appeal board for a post-grant review and inter partes review in the U.S. Of course, that came out of the 2012 amendment. And I think to the patent law, and it's really going to be incumbent upon many parties, many stakeholders, patent right holders, and inventors to really get that legislation or those practices in a better shape. Right now, I would say that the effect of using post-grant review and inter partes review in the U.S. has been very, very detrimental to patent right holders. And so to answer your question directly, I think one thing is to have reform in how we in the United States conduct inter partes review and post-grant review, which has been leveraged a lot more than we anticipated by patent assertions entities. On the other hand, patent assertion entities do have a right? They are the right holder, right? They don't want others to infringe or they want to have the ability to exclude others from infringing on their property rights. So there's got to be a balance there. On the whole, my view is that the balance should be more equitable IPR and more even-handed IPR and PRG review in the U.S. That would help.
Are there? I know there are equivalent procedures, or at least comparable procedures elsewhere. Do you see these being potentially abused in other countries, or are they being used properly? And have we seen an increase in assertions by patent assertion entities elsewhere? I know with the UPC, Coralie mentioned that at the beginning. Is that a concern in Europe?
It could be. You're right. It could be. In Europe, we are very, very prone, and we understand the deposition practice very well. I mean, hands down. What an efficient, I think, process. What a cost-effective, efficient process. And as far as I can see in 3M, we don't see as many patent assertion entities against 3M outside of the U.S. And we use the opposition practice because it's such a well-known, well-oiled machine, well understood. And I think that has been working very well for us in the opposition practice, in the EPO specifically.
Are there comparable procedures in South Korea, Grace? I'm not as familiar with the law there.
Actually, we also have the opposition system before. So after after the allowance, after the registration, we can make the opposition too. So maybe we have previously, from even a long time ago, we had those kind of system too, because we actually the focus is different, because in Korea we focused on more industrial development than the protection of patent holders. So we wanted to make sure about the protect the public interest before the enforcement. So I think that's why we had those kind of system for even long time ago. But actually these days, but I won't make another issue. These days we also had some issue about the public interests about bio patents because of COVID, because many patients need to be treated, but if the license, if the patent is really the protect the patent only patent holders, then many people cannot be treated with cheap prices of the medicine. So these days in Korea, in the electrical area, so we are going to into protection of patent holders, but in healthcare area, so we are pursuing some kind of the enforce a license for protection the public interest. So those kind of things are, each area has different issue in Korea. So maybe, case by case, in case area by area.
So let me close by asking just a very broad question, and then I'll hand it over to Tim. But what do you see as the future of international intellectual property? I know that's a very broad question, but do you have any advice, say, for our current students or prospective students, some of whom might be listening in this morning, on what they might want to do or how they might want to get involved in this area?
Professor Cotter, maybe I can join.
Sure.
I can jump in. I think first of all, you should take participate in this kind of panel session, definitely. And secondly, maybe take classes from Professor Cotter. And thirdly, of course, I think what we actually talk about is that inform yourself, educate yourself by just participating, connecting via a lot of platforms, social media, internet, or international associations. Familiarize yourself with different regions of changes and developments. I know it's difficult to catch up all the changes around the world, but if you want to work for a company like 3M, like Alibaba, or a Giant, or you work in law firms like maybe Kohali in Paris, or maybe like Grace in Korea, serving international clients, you definitely need to have a very good grasp of all the changes in different areas or in different countries or regions, and you cannot stop learning. And I think that's my advice. So if you are already studying at University of Minnesota Law School, then congratulations, you are on the right track. But you got to take the best use of it. That's my 2 cents. Thank you.
Yeah, to add upon what Pei Huang just said, I think not only you need to familiar with the change and then laws in different jurisdictions, you actually have to familiar with how your businesses operate, right? And what's the key technology? What is key to protect for your product in a commerce perspective? Either it's on a physical market or on the e-commerce market, so that you can design strategy to protect your business interest. And I think that's the key to have a good patent protection to begin with. I mean, plus other IP rights, copyright, and trademark as well.
All right, Tim, should I pass it on to you to conclude our session this morning?
That's great. Thank you, Professor. And thanks to all our panelists, Yen, Pei-Wan, Xinghao, Grace, Corley. Thank you for your time today, in morning, evening, for supporting this, and Professor Cotter for leading us in a wonderful discussion on so many broad topics on IP that showcase the breadth and the unique and common areas that this touches on. But wonderful. We could probably go another hour at least or so, but we'll give everyone back some of their time today. So thanks again. In particular, I also want to thank my colleague, Lizzie Begelli, the Director of Alumni Relations and Annual Giving at the law school, who did all the heavy lifting to produce today's event. Thank you, Lizzie, and to the advancement team at the law school. And again, share our gratitude to Dean Jenkins for all the great things happening at your alma mater for those who are participating and listening today. So with that, we'll conclude today's event. Again, thanks to all for questions or comments. If you have anything you wish to share, please reach out to Lizzie or myself. And thanks everyone for your time and support, and wish you all well. Stay safe, take care.